but you can still see where they went. And ladies and gentlemen, by the time this is done, when you've heard all the witnesses, when you've seen all the evidence, when you've brought your own God-given common sense to bear, and you contemplate that all, the state is confident. There is no question as to. There is no question as to how. The only question is to how long he thought about it before he wrapped that bolt action 22 and put it up to the back of that little girl's head. He is guilty as charged. Thank you.
I'm sold. No, we gotta wait for the defense. Let's bring in New York, trial attorney Mackenzie Joy Brennan. The blood got me. Her blood in between the seats after the squirrel story. Sorry. And the disgusting motive for this. If I'm a juror right now, before the defense, I'm thinking, overall thoughts here, and what do you expect from the defense?
Yeah, it'll be interesting. I'm glad that they had a somewhat masculine male prosecutor do this, because this type of crime is so gendered. It's the type of thing that just makes my blood boil. 14 and 19 years old, I'm glad he referred to her aptly as a little girl. And you can hear that he's trying to preempt some character smears that are going to come out inevitably from the defense. You know, the fact that he had to mention that she was going down a bad path, but is a child. And, you know, that's not her fault. That is not an invitation to be exploited. And when you see this type of gendered entitlement, and frankly, pedophilia, this like weird pedophilic culture, it's predictable then that somebody in the defendant's alleged position would perceive her as being disposable. So I'm I'm with you.
I think
we'll see what happens.
The cryptic messages from the state saying we acknowledge we're getting a lot of different stories from a lot of different people. This seems like a defense of my guy's not great, but he didn't do this. He runs with a circle of horrible people.
Sure, yeah, that'll be interesting to watch come out. I wonder if this younger relative, the 15-year-old, will get placed in some culpable situation, although he, of course, was more age appropriate for this girl and didn't have the blood in the car. But I think you're right, with the vehicle being potentially shared between folks. On the other hand, it does sound like this defendant has his own record already. Like, he refers to himself by a different name. It sounds like diagnosed himself as bipolar. We'll wait and see if that comes out further in the defense's opening, I guess. But he does not sound ill-suited to this type of crime, if you will.
Yeah, we'll see. We don't want to jump to conclusions after just one side. Let's get a commercial break and jump in and watch the defense. See what the defense is for Waymore Gerhardt. Is it going to be a pointing the finger at somebody else? What will the defense be? We'll find out next. We'll head back to Florida for the defense opening statement in our new trial in just a minute. But first, here's a quick look at what we're tracking today at Court TV. In New Jersey, closing arguments underway for a man accused of killing his brother and his brother's family and then setting their house on fire. You can stream that at courttv.com. In Georgia, the state's case continues for a man accused in the cold case killing of a University of Georgia law student more than 2 decades ago. We'll update you throughout the day on that one. And in North Carolina, the defense case continues in that hearing, the Miller hearing, to determine whether or not a teenager who pled guilty to a shooting spree should spend the rest of his life in prison with or without parole. We'll watch all of these trials, update you throughout the day. But right now, heading back to Florida, our newest live trial, the fatal rejection murder trial for Waymore Gerhardt. Let's go back in and see what the defense has to say to this jury.
This world failed Demiah Appling. That failure started not on a night in mid-October. But long before that, and some of the things that Mr. Gerhardt talked about in his opening statement, I've got a child who is at the point where she's running the streets, missing for days at a time, reports of drug use. And finally, we come to some of the things that happened that Mr. Gerhardt's told you about. This is a difficult situation because we're going to ask you to make one of the most difficult decisions that a jury can make. There's something terrible that happened in the search for an explanation. But the issue is not so much that the world failed Demiah before she was killed. There were numerous people that failed Demiah leading up to her being killed and after she was killed as well. There were failures in the investigation, failures by people who were involved in this case to tell the truth. A lot of them. That's your job, is to figure out who's telling the truth, who's not telling the truth, what parts of what they say is the truth, and what parts are not. You're going to hear from a number of individuals over the next couple of days who are full of a pack of half-truths, self-interest, and strategic amnesia. I want you to think about the idea of strategic amnesia. I can remember things that make me look good and that make Mr. Gerhardt look bad, but I can't remember other things that might make me look bad. That is going to be a theme in the testimony that you hear from Keith Anderson, who can't quite decide whether or not he was putting Demiah in danger. He can't decide that. Even though he's been asked to do all these text messages, according to Mr. Gerhardt, according to the text evidence, he's been asked to do these things, but he can't decide. He's kind of back and forth on that issue. That's a failure right there. You're going to hear about numerous portions of the investigation where decisions was made during the investigation that Mr. Gerhardt was their prime suspect. But that wasn't always consistent with the evidence. And one of the things you're going to hear about, I feel confident that at some point during this trial, you're going to have the chance to see a .22 long rifle. I feel confident the state will put that in. Okay? And you're going to hear about some of the forensic testing that was done on that .22 long rifle. You're going to hear that there is DNA on that long rifle that they still don't know. They still don't know. Today, they don't know whose DNA that is. Today. But at some point, we just decided that we're ready. Right? It took too long to ready. You're going to hear the state's theory of the case is that Mr. Gerhardt himself, with no one else involved, abducted someone in a passenger vehicle and somehow managed to get them by himself behind her and shoot her in the back of the head with a rifle that's this long. Now, I want you to work through the mechanics of that, of how that would work. How you would threaten someone in a car, that's what you've got, and they're in the car with you. How you would get a person in a vulnerable position when that's your only weapon, how that would work. Now, I suggest to you that that does not add up, that there are individuals involved in this case who have never been named. Never been named. And it was a failure of the investigation that led you to be here today. This trial is a failure of the system. Because instead of getting to the bottom of this, we have someone who was involved, but who was not the killer. Now, I'm not going to stand here and tell you that Mr. Gerhardt didn't do anything wrong, because that is not true. Okay, that is absolutely not true. Clearly, the forensic evidence shows that he was very much involved. Shows that he was out and about that night. I think that the forensic evidence that you're going to see from some of the witnesses show that he did lie to the police and he did go out, he did do things. He probably buried her exactly where they say he did. Cleaned up the backs of Max Lyon's vehicle. But he did not shoot her. And the physical evidence is consistent with that. The mechanics of how this occurred are consistent with that. And I want you to listen carefully. I want you to listen carefully. The state's going to tell you that they don't have to prove motive, and that is true. They do not have to prove a motive. But people do things not just randomly. They do things for a reason. And there is no reason here. There is absolutely no reason. None will be provided by the testimony of the witnesses. None was provided by the state in their opening statement. There was no reason.
All right, a little video freeze there, but we get the gist of it. The defense opening, as we sort of talked about, it's one of the other guys that he ran with. Let's bring back in trial attorney Mackenzie Joy Brennan. Involved, but not the killer. Probably buried her, did that poor cleanup job in Max's car. Interesting. They're willing to basically admit a lot. So he's going to prison. They get that. This defense is all about not spending the rest of your life in prison. Is that what you're taking here?
Yeah. I was, in fact, surprised at how much they're willing to cop to, especially in the absence of a plea. You know, if this is the best version of the defense, if this is the compromise such as they could reach with what their client would admit, that's pretty bad. You know, you have the blood in the car, you have potentially burying her, but all they can say is he likely didn't shoot her. If that's the best defense, even if I were leaning a different direction, I would feel a little concerned for what the jury might do with that. And invoking Keith's strategic amnesia, that to me is so far from indicating somebody's guilt. It's so common, especially if you're talking about a 14 or 15-year-old, to have patchy memory of a traumatic event, to, you know, allow your social circles to manipulate what you'll admit. That is so far from connecting him to the actual shooting itself. So it almost sounds like the best that they can offer is she ran with a rough crowd, so somebody else must have done it, but my client helped. Mm-hmm. That's not the strongest defense I've ever heard.
No, I mean, you're not getting a lot of empathy for the guy at the defense table. But, you know, on the other hand, he did a good job of creating an image of maybe the defendant driving and their long gun is at the head of this poor 14-year-old because it's a group of people and someone whose DNA has never been identified. You know, this mystery person's DNA is on that rifle. Watch for that. I don't know. It's worth a shot. It sounds like they've got a horrible case and that he is involved deeply and that 14-year-old's dead. But there's potential for him to hit a lesser if a juror or the group believes hasn't been proved beyond a reasonable doubt because of this 22. You know, that could be the saving grace for him to not spend the rest of his life in prison.
This is all about reasonable doubt. I think you're so right. I'm very interested to see what evidence they have of other folks because jurors, frankly, all of us, like a concrete alternative solution. So just saying that, say, they don't know whose DNA is on this gun, or she ran with a lot of sketchy people, trust us, or this car was shared by a lot of folks, give them something tangible and some other plausible perpetrator. And it sounds like they're not going with Keith being the perpetrator, at least from what I heard.
No, I picked up that Keith didn't do it, but he's a liar and he won't tell you who did it, and he knows.
Right.
But
So that
okay, well, the
requires
defendant
yet
knows
another
too. Then,
person.
if the defendant was in the car and there's this other person, the mystery man, he knows who it is. But so I think there's a good chance.
And
that,
would have every incentive
right
to share
So,
if he did know.
I think the jury might be like, we're not sure, but this guy's bad. So we'll see. Let's get a break. We'll pick up hopefully the rest of the defense opening and then the first witness of the day. Stay with us.